Welcome to the Ask Junior Daily Judgment Podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgments. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now let's get started with today's case. Today we're focusing on a judgment from the National Company Law Tribunal, NCLT, in the case of Vipul Jain and Ors versus Raheja Developers Limited. This case revolves around the concept of corporate insolvency and the legal framework surrounding it.
That's right, Priya. This case deals with a common scenario in real estate: delayed construction projects and frustrated homebuyers. Vipul Jain and 42 other individuals had invested in the Raheja Shilas low-rise project in Gurugram, Haryana. They had paid over 95% of the purchase price for their units, but despite a promised delivery within 30 months, they were left without possession.
So, these homebuyers, or financial creditors as they're called in this case, decided to seek legal recourse under the Insolvency and Bankruptcy Code, IBC of 2016.
Exactly. The IBC is a landmark legislation that aims to streamline insolvency proceedings in India. It provides a mechanism for resolving corporate debt distress in a time-bound manner. In this case, the homebuyers filed an application under Section 7 of the IBC to initiate a corporate insolvency resolution process against Raheja Developers Limited.
To understand the implications of the NCLT's decision, let's break down the key legal questions involved in this case.
We need to determine whether this Raheja Shilas low-rise project stands as an independent entity or is just a part of a bigger group housing colony project, as claimed by Raheja Developers. This is important because the IBC requires at least 10% of the financial creditors to file for insolvency, and the number of creditors in each project matters.
Furthermore, we need to assess whether the delays in the project are solely attributable to Raheja Developers or can be attributed to force majeure conditions, as argued by the developers. Force majeure refers to unforeseen events that are beyond the control of a party, such as natural disasters or acts of war, that can excuse them from contractual obligations.
We also need to examine if the fundamental elements of debt and default are established in this case. The homebuyers clearly had a financial obligation to Raheja Developers, but did the developers' failure to deliver possession constitute a default according to the IBC's definition?
And finally, we must consider whether the NCLT can initiate a partial CIRP only targeting the Raheja Shilas low-rise project while the developer has other ongoing projects.
Let's delve into the court's reasoning. Regarding the project's status, the NCLT meticulously reviewed documents, including the developer's affidavit and RERA registration details. It found that even though the developer initially claimed Raheja Shilas low-rise was part of a bigger project, their own actions and submissions contradicted this claim. The NCLT especially focused on the separate RERA registration for the Raheja Shilas low-rise project, indicating its unique specifications.
This aligns with the very purpose of RERA, the Real Estate Regulatory Authority Act, which mandates separate registration for distinct phases of real estate projects. The court emphasized that the specific project with its 94 units should be considered a standalone project for the purposes of insolvency proceedings. With the 43 applicants representing over 10% of the project's allottees, they met the required threshold for filing under the IBC.
On the issue of force majeure, the NCLT addressed the developer's argument that delays were caused by the difficulties in obtaining various NOCs, no objection certificates, and the occupancy certificate. However, the court held that these procedural challenges were standard formalities that developers should anticipate during real estate development.
It pointed out that the developer had successfully obtained the occupancy certificate for other phases of the project, yet delayed the application for this specific project until 2017. The court emphasized that complying with regulations, securing NOCs, and acquiring the occupancy certificate are inherent aspects of real estate development and cannot be classified as unpredictable circumstances.
The developer's contention regarding litigation with government departments was viewed as a business risk rather than a force majeure event.
Regarding the existence of debt and default, the NCLT meticulously reviewed the allotment letters, payment proofs, and default calculations. While possession was due in 2012 to 2014, the court determined that the developer had continuously acknowledged the debt through ongoing communication with homebuyers.
The court concluded that the developer's failure to deliver possession constituted a continuous default, meaning the homebuyer's application was filed within the statutory limitation period. The court stressed that obtaining the occupancy certificate is a critical obligation for any developer, especially since it is directly linked to essential utility services and the project's readiness for habitation.
Now we come to the crucial question of whether the NCLT could initiate a partial CIRP against only the Raheja Shilaz low-rise project. The court acknowledged the homebuyer's desire to limit the insolvency process to this specific project, but recognized the existing limitation in the IBC framework.
Under Regulation 36A(1) of the IBC, while a resolution professional can invite separate resolution plans for different projects after admission, the framework does not allow partial admission of CIRP against a specific project of a company. The NCLT noted this limitation in the current law, suggesting the need for legislative intervention to address such situations.
Finally, the NCLT admitted the application for initiating the CIRP against Raheja Developers Limited, putting the company under a moratorium. This means the developer's assets are protected, and no creditor can take any legal action against them except under the IBC process.
An interim resolution professional, IRP, was appointed to oversee the process, who will be responsible for investigating the company's financial situation and developing a resolution plan to address the debt and attempt to save the company.
To illustrate the complex concept of insolvency and the IBC framework, let's think of this situation like a house fire. The company is the house, and the debt is the fire. The IBC is like the firefighters who arrive to assess the damage, control the fire, and try to save the house.
A partial CIRP would be like trying to control the fire in just one room of the house, while the rest of the house is burning. The IBC currently doesn't allow for such selective firefighting.
This judgment underscores the important role the IBC plays in protecting financial creditors, especially in real estate projects. It also highlights the need for greater clarity and flexibility within the law to address situations like this, where a company has multiple projects with varying levels of debt and default.
This case also reminds us that developers have a responsibility to ensure timely completion of projects and meet their contractual obligations to homebuyers. While unforeseen circumstances can occur, they can't be used as an excuse to shirk those responsibilities.
This judgment adds to the growing body of law regarding insolvency and real estate development in India. It offers valuable insights into the application and interpretation of the IBC within a complex real estate scenario.
And that wraps up our analysis of today's judgment. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta, signing off. Thanks for listening to the Ask Junior Daily Judgment Podcast.